Hello, I'm Constitutional Attorney Katherine Henry, and today is a continuation of our mini-series on 85 of the most common criminal law terms and their definitions. So to jump right back into it, false arrest. It can be within the context if you think of, I'm gonna sue you for false arrest kind of thing. False arrest can actually come up in the context of a criminal case, or a civil case, because you could sue someone afterward in a civil case for the false arrest. But false arrest is any unlawful physical restraint of another person. It doesn't have to be throwing them in jail or prison. It can be, but it's any unlawful physical restraint of another person. False pretenses is misrepresentation to obtain another person's money or goods. Felony is a serious crime, generally punishable by death or imprisonment in a state prison for more than a year. So the general rule of thumb is that misdemeanors can be punished for anything from 0 days up to 1 year in jail. And then felonies can be punished 1 year in prison and up. Fraud is the intentional perversion of truth to deprive another of property or to induce a person to surrender a legal right or to injure him or her in some other way based on untruth. Habeas corpus, you have the body, is what that means. The name of the writ used to bring a person before a court or judge. Usually the defendant is asking to have themselves brought before the court or judge. Generally, the writ is addressed to an official or person who holds another. It commands him or her to produce the detained person in court so that the court may determine whether that person is being denied his or her freedom lawfully. Indictment. A grand jury's written accusations that charges a named party with the commission of a crime. Information, a formal accusation of the commission of a criminal offense made by a competent public officer, such as a prosecutor, rather than by indictment of a grand jury. So a criminal case might start by a criminal complaint being filed, and sometimes that document is actually called the information. Super confusing and stupid, if you ask me, because information is a widely used term in a lot of other respects. Or you can have an indictment that is after evidence has been presented to a grand jury, they then decide if there's enough evidence to proceed with the prosecution, and then they sign off on an indictment. Instruction is a statement made by a judge to a jury at the close of the trial about the law that has to be applied in that particular case and the procedures for how they should do so. Jury, in general, is a given number of persons selected according to the law to determine issues of fact on the basis of the evidence submitted to them. And juries only ever decide issues of fact. They never decide issues of law. Those are decided by the judge. Now, a grand jury is a jury of inquiry that receives complaints and accusations in criminal cases. It hears the prosecutor's evidence and issues indictments if they are satisfied that there is probable cause to believe that a crime was committed, that the accused, in fact, committed the crime, and that a trial should be held. A petite jury, though, is the ordinary jury, right, of 12 or sometimes less, such as 6 in a typical Michigan misdemeanor case, for example. But it's an ordinary jury of 12 or less persons selected to hear the trial of a civil or criminal case and to determine, again, only issues of fact, no issues of law. And they are called the petite jury. It's the official title is petite jury, just to distinguish it from a grand jury. A lien is a claim against property to secure a debt or other obligation. Locus delicti is the place where the offense was committed. Malicious prosecution, an action initiated without probable cause to believe that the charges could be sustained and for the purpose of injuring the defendant. Manslaughter is the unlawful unaliving of another without intent to unalive, either voluntarily or involuntarily. Voluntary manslaughter is the unaliving of another on sudden impulse. Like a quarrel, a fight erupts into a fist fight, which then one of the participants is unalived. So you just start with an argument, all of a sudden their emotions are high, and then they're throwing punches, and then somebody ends up accidentally unalived. That would be voluntary manslaughter. Involuntary manslaughter is the unaliving of another during the commission of an unlawful act, not ordinarily expected to result in great bodily harm, or during the commission of a lawful act without proper caution. So, for example, if you're driving an automobile, if you're driving your car with an excessive speed, you are going 70 in a 30-mile-an-hour zone, and then all of a sudden you have a fatal collision, that would be involuntary manslaughter. Misdemeanor. Those are offenses less serious than felonies, generally punishable by a fine and or imprisonment, usually in a local jail rather than a state prison, and generally only up to 1 year. Mistrial is the termination of a trial before the verdict, where the case is ordered typically to go to another trial, so a retrial, because of some basic flaw, like an event in the courtroom that jeopardizes the rights of one of the parties to a fair trial. Somebody has some huge outburst, or something happens with one of the witnesses. A mitigating circumstance is one that, though it does not excuse an offense, it reduces the degree of blame, particularly relevant to the extent of punishment to be imposed or whether punitive damages should be awarded. So generally speaking, mitigating circumstances are totally irrelevant to whether somebody committed the crime, but only relevant to how long they should be sentenced. So for example, in the case where we were victims of the crime of one of our neighbors, she did not try to offer any kind of mitigating circumstances for whether she committed the offense, but at her sentencing hearing had a litany of really terrible mitigating circumstances she was trying to present, why the whole world is just, out to get her, and her life really sucked at the moment. And so, she was just coming to our house with a sledgehammer to physically threaten harming my son and then smashing our property. And anyway, needless to say, she did receive a fairly decent sentence. But anyway, moral turpitude is conduct that is inherently unethical or immoral, as distinguished from conduct that would be proper, except for there's a statute that prohibits it. So moral turpitude is kind of like the malum in se, as opposed to a malum prohibitum offense, which I've talked about in a lot of other videos. I was going to give this definition, but I'm not going to because I'm going to get dinged on the platforms. But you can imagine what unaliving definition I was just going to provide you.